Good afternoon, everyone, and welcome. It's great to have you with us for the first webinar of the year. Before we begin, I'd just like to take a moment to acknowledge the traditional custodians of the lands on which we're meeting today. For me, I'm dialing in from Sydney, so that's the Gadigal people, and I pay my respect to all elders past, present, and emerging, and I extend that respect to all Aboriginal and Torres Strait Islander people joining us today. This afternoon's webinar will explore child inclusive practice and what that looks like in practice, when it can be helpful, when it may not be appropriate, and how lawyers can work with other professionals to get the most out of the process. We are very fortunate to be joined by Dr. Alison O'Neill and Skye Owen. Dr. O'Neill is a clinical psychologist with 25 years' experience working with children and families. She has completed a PhD looking at the quality and consistency of single expert reports in family law proceedings in Australia, and she has written over 400 expert reports in various jurisdictions. And most importantly for today's session, she is a collaboratively trained practitioner and a member of the Australian Association of Collaborative Professionals. She has a private practice based in the Sydney CBD. We're also lucky to be joined by Skye Owen, who is a special counsel at Land & Rogers. Before entering private practice, Skye worked as an associate to a judge of the Federal Circuit Court of Australia, as it then was. She's an accredited specialist in family law and has been practicing exclusively in family law for 17 years. We'll leave time at the end for questions, so please feel free to submit those through the Q&A box, and we'll try to get through them as we go. And the only other housekeeping comment is that a copy of the slides and the recording will be made available after the session. So without further ado, I'm going to hand it over to our presenters.
Thank you, Dina. I just wanted to start by asking Alison, can you tell us, Alison, why you pivoted into child inclusive practice?
Sure. Well, a lot of you probably know I wrote a lot of single expert reports. And while I loved them and I loved the cross-examination that went with them, I got frustrated, increasingly frustrated, I think, by the length of time that these families were caught in litigation and the extra stress that put on the whole family, financially, emotionally, but also on the children. There was often a need for repeated interviews and updates. And I found myself frustrated that if something had happened back then when I wrote the initial report, these kids might not be in that position. I also I guess, kept sort of thinking about ways that I could intervene earlier. And so I started to do a lot more of the child impact reports, and I think that they can be very useful if they're done for the right cases and at the right time. But I see this as an opportunity to do a really simple, quick intervention early that hopefully will reduce the amount of stress that the kids are going through and make some changes in the dynamics of the family. Really, that's how I kind of perceive child inclusive practice is really trying to get the parents working together again, and the parents working as a resource for the children so the children can trust that dynamic and there's some kind of repair, if there's been a rupture in the family, like a separation.
So from my perspective, I suppose as a lawyer, I see it in the same way. So what I love about child inclusive practice,
Yeah, what do you like about it, Scott?
I love the fact that it brings the focus back to the kids, which is where the focus should be, and it takes us away from the adult drama. I guess as family lawyers, we often hear parents arguing about schedules and changeovers and who they think's being unreasonable. But then you introduce child inclusive practice, and I find from my experience, the conversation suddenly shifts. So rather than debating whether a changeover should happen at 6 o'clock or 7 o'clock, we learn that, surprise, surprise, the child actually dreads the changeovers at all because it happens in a supermarket car park on a Sunday night when the child's tired and emotional and both parents sick of both parents arguing. And I think that insight alone can really change the outcome. Not because one parent wins, but because the child's experience is finally visible to both parents. Another thing that I really love about it is it gives children a voice without giving them responsibility. Children aren't asked, and Alison, correct me if I'm wrong, but I'm pretty certain they aren't asked, who do you want to live with as part of that process, which would
Hopefully
be
not.
unfair and completely damaging. Instead, a trained practitioner like yourself might feedback that a child feels anxious when one parent asks them to report on the other parent's behaviour. And I've seen that that kind of feedback directly to a parent is far more powerful than any affidavit or any letter. Parents often dismiss, in my experience, what's written, but it's really, really difficult for a parent to dismiss directly a child's emotional reality. I think that it also improves outcomes in a really practical way. Um, and I think that that is one of the real benefits because it gives children breathing space, and that's when you can get workable outcomes.
Mm. Well, let's face it. I mean, once they've written those affidavits, I think it's hard to come back from that. They've really aired all
That's
their
right.
dirty laundry. They've said every terrible thing, which for any of us, if you did that over, a 20-year marriage, um, it would be very hard to move on and mediate and settle. So I think if you can do anything for the kids before that, I think that's a really good positive outcome. And Sky, when would you recommend child inclusive consultations, or when would you not as a lawyer?
Yeah. So when I'm talking to clients and I'm considering whether this matter is right for child inclusive practice, I'm really asking myself a core question, which is, will this process benefit the child or will it risk adding to their stress? CIP or child inclusive practice is powerful, but it's not appropriate in every matter. And it's certainly there are a lot of cases where it's not appropriate. So I'd strongly recommend it in cases where I think the parents have the capacity to reflect and engage. And in those matters, I see the child inclusive feedback acting as a circuit breaker. Um, and I think ultimately, when both parents are struggling to understand their child's experience, and you've got parents that are well intentioned but stuck in adult logic, um, they might be cases where child inclusive practice can help because they're translating child's development needs into language that the parents can actually work with. I, however, would be cautious about recommending this type of intervention where there are significant risks to the child's emotional or physical safety. For example, in cases where you have serious allegations of family violence or untreated mental health issues, the process in those cases could be harmful to children and place unnecessary pressure on a vulnerable parent. So I think in those cases, even indirect feedback can be misused or create fear about consequences for speaking honestly and can do more harm than good. I think ultimately, I leave the decision as to whether to proceed with child inclusive practice to people with a lot more experience in assessing those matters, because I don't obviously have the benefit of meeting with both parents. I only can hear my client's version of events. So if I think that the matter is amenable to a child inclusive intervention, then I would refer the client to someone like you, Alison, or a child inclusive practitioner, and I would have you assess the matter as to whether or not that the matter does meet the criteria and whether it should proceed to involve the child.
Mm.
Alison, I mean, you're making those assessments all the time. When do you think that sort of intervention is helpful or not?
Well, I think not surprisingly, very similarly to what you said, I'm hopeful that the mediator and the lawyers have considered what's suitable and what's not. Um, but the child consultant is really the gatekeeper because they're the only one, or I guess the mediator too, but they're hearing from both parents, and then they have some understanding after interviewing the parents if there's any of those, red flags for when you would not proceed. And at that point, I think it's up to the child consultant to say that they wouldn't proceed because it could be harmful to either parent or the child or children, or it's just not a suitable matter. And for me, what I would do in that situation is just refund the rest of the money, the package that was paid, because at that point you're stopping the process really. Um, but if there are allegations of, as you said, serious issues like substance abuse, and I say serious because we've all heard them that are, not or similarly serious mental health issues or family violence, or if it's just, as you said, that the parents are going to use this and weaponize the whatever the child says. So if I'm hearing in the parent interviews that they're looking for sort of some of this evidence or ways to promote their own outcome or interest, then I probably would suggest that I don't see the child and that it's an appropriate case for a child inclusive consultation. But I think, so I guess I'm always kind of thinking, first do no harm, the Hippocratic Oath, you're thinking about the child, you're thinking about the family. But having said that, there's lots of times when I think this actually could be used more than it is now. Often when I see families in a child impact assessment, I think this could have been a better way, an earlier way, a cheaper way, a faster way to intervene. And I think in times where there's really a genuine and heartfelt intention of the parents to avoid litigation and really hear the child's voice and experience. I think what often happens when you write a report, and probably the lawyers, I've heard this, single expert or child impact report, they skip to the end to look at the recommendations. And I think what's missed in that is that chance to hear the child's voice and experience. So CIP is that, opportunity, I guess, to do that. For me, I think when it's really useful is when there's, young children and say one parent is demanding equal time and they're a bit stuck in that fair concept, or it's an adolescent and the parents haven't really cottoned on to the fact that this kid's grown up a bit and is having a different experience to what they think of as a child. So anything really, or in a neurodivergent child, or even when one or both parents might have, let's say they're on the spectrum themselves and they're having difficulty with the child or children who are also on the spectrum, it can just give you a different way to kind of hear the children's experience and educate the parents, but in a neutral way.
I was going to say that it often serves, in my experience, an educative purpose as well. Because whilst you're having the child's view front and foremost and up there, and so the parents can see it, at the same time, you're also, in some sense, teaching the parents, particularly with little kids, when you might have that example with a young child and both parents are seeking, or one parent seeking equal time and the other saying, no, I don't think that's right. You're almost sitting down with the parents and saying what the developmental considerations are that should be taken into account as well, that we as lawyers don't have that necessary experience to do.
I think that's exactly right. You're able to overlay that developmental lens or attachment lens or lens of a neurodivergency or whatever that lens is that's kind of needed in that particular matter. So it can be that education. You can also hopefully then explore, what it is that the parents' interests and concerns are, and kind of feed that back. And it's also that educative role, I guess, between the parents. And hopefully you're kind of thinking of cases where it might help to do that early intervention and then review it. This can be an open-ended kind of conversation then for the parents. So we're trying to put the parents back in the hot seat as being the experts and helping them to hear, if they can, what's going on for the child. So I wouldn't recommend it if the lawyers tell me that they can't hose down the parents, then I think that's probably not a case for the child inclusive.
But to use you as a resource as well, an important resource, and I think that's essential, because I like the idea of reviewing over time, because it could be that you review every 12 months. How are things traveling? Do we need to tweak things?
Yeah, that's right.
Yeah.
That's right. And if you're genuinely interested in how the children are experiencing transitions or the time arrangement or the plan, then hopefully as parents they're open to hearing from that and changing that and tweaking that.
hmm And I guess that's the difference between fundamentally how CIP works and how reports in formal court proceedings work.
Yeah, well, what do you think is the difference really? Like when would you use it? When do you think a report is necessary versus,
The child inclusive
you don't
practice.
the report aspect?
Yeah. So I think from my experience, child inclusive practice is a much more flexible process, more flexible, supportive, and fundamentally it's confidential. So it's not used in litigation. I
Why
guess,
do you think that's important, Sky? Sorry to
yeah,
interrupt. I know
no,
a lot of people get caught up on the subpoenaing and that it's confidential, but why do you think as a lawyer that's important at this stage?
yeah. Well, from I guess the child's perspective, I suppose they feel like they can give a view in a sort of safe, protected space without worrying about how it might be used. Similarly, from the parent's perspective, I think that's important as well. They can actually be open and not have that concern about, well, how's this going to be used against me in litigation? Because we know once we're in litigation, it's very much you're in your own corner and everything's under the microscope of the court. So I think that that having that confidential process early is really good because it means that the parents and the child can really open up and feel safe in that space
Mm.
to do so.
And I should say, though, as a psychologist, I have to take notes. So that only works really if it's under that FDRP
That's right.
process.
Yeah. So it very much is confidential under that process. Court reports, as you know, on the other hand, are a completely different beast. They're formal documents prepared by professionals like yourself, specifically for the purpose of a judge seeing them.
Mm.
They're assessing family dynamics, evaluating how the child's traveling, making recommendations. So, and they're in writing, fundamentally, they're in writing and they're admissible in court. Um, I
I
guess,
like that, Sky. I think the audience is different.
yeah,
That's really what makes them a different beast, right?
yeah,
That when I write a report, the judge is my audience essentially.
hmm
When I'm doing the, child inclusive work, you're really pitching it obviously to the parents
yeah,
without really
that's right.
thinking about any of the legal consequences.
And also, it's not influencing a legal decision. It's really not. It's influencing how these two parents are going to implement arrangements for the best interests of their child without influencing a court ordered determination. So I think child inclusive practice, in my experience, empowers children in a way to be able to have their view heard by their parents, who are
Mm.
the ones that are ultimately then going to be implementing certain arrangements for that child. Whereas when you have these formal reports in court, I guess the views of the child are taken into account at some point by the judge, but it's a very different audience. And I think that is the essential difference.
Yeah. And two questions I guess I have from that, Sky. What kind of cases then would you say this definitely needs a report? And then the second part of what I was thinking when you were just talking there was it's a different contract that I would have with the child in terms of informed consent when I'm just reflecting back to their parents versus reflecting back to
The court.
lawyers, the
Mm,
court, and it goes everywhere. You can't control that beast of a report.
mm. So I
But
think
when would you say
cases
they really, what kind of cases really need the reports?
entrenched conflict, like conflict where there is zero communication between the parents. I think cases where you have personality difficulties
Mm.
or dysfunction, and they're often difficult cases to pick up those types of cases in a short period of time. So I'd be relying often in those cases on your assessment of the parties and the experience that you have doing that. But I think personality issues often need a report.
So you
Entrenched
wouldn't
conflict,
rely on just one parent saying that about the other, that they had
no,
narcissistic personalities.
no, no. But I think the entrenched conflict, and I think the really serious family violence
Yeah,
cases,
yeah.
and also cases where there's allegations of abuse against a child. would not be amenable to that sort of intervention. They'd be matters that I'd be really concerned to suggest that as an intervention, because in cases I think where there's a vulnerability.
Yep. And I think from a psychological perspective, then, as the child consultant versus report writer, I think it's important for lawyers to remember then that I've got no other, in a child inclusive matter, I've got no other documents to rely on. I'm not going to go and speak to people's treating psychologists, psychiatrists, the kids' school. It really is just taken at face value from the parents. So if there's any allegations that are really serious and they need to be explored for an expert opinion, of course, I'm not the trier of, fact in that world, but I'm asked for an opinion. It's very different, what I'm trying to do. It's not evidence gathering in the CIP, where in the same way that it is in a court report.
And I think we also have to be really mindful as lawyers about referring the right types of matters. And it really, in my experience, when I think, oh, this matter might be amenable to this sort of approach, is looking at whether my client has a capacity to reflect. That is really important from my perspective. But I also have to keep in mind the risk that if this process falls through and doesn't help in the way that it should, I'm putting that child before another person to speak to. And because if court proceedings are going to be initiated, this child is potentially going to see you, Alison, and then potentially see up to 2 different experts if we get a short report and the more comprehensive report, and potentially an independent children's lawyer. So we want to reduce the child's exposure. And if we're assessing these cases too quickly or incorrectly, then we're leading to this child being exposed to further intervention, which is not best for them either.
Yeah, I agree, Sky. I mean, I think that there's, you got this sort of one shot at it, and the same person wouldn't be doing a child inclusive consult, wouldn't be the same person then writing a child impact report. I mean, that child impact report writer could potentially write the single expert report. But I had a case just recently where I was the third child impact report writer that these children had seen. And I did scratch my head and think, I don't know why they didn't go back to the first person. I mean, it's bad enough that they had to have 3 interviews, but why not at least with the same person? But yeah, I think that the more we're exposing kids to further interviews, it puts pressure on them. I mean, it's uncomfortable, even though most of the time actually kids quite like talking, but they don't want to do it repeatedly, and they don't want to think, well, I've already told this to multiple people and nothing's happened.
And don't want to say it again. And the other thing I would say is, coming back to the really important word here, which is collaborative. The lawyers should be getting together and having a conversation about this. And I should be picking up the phone to my colleague on the other side and saying, look, I actually think this matter might benefit from child inclusive practice. My client's pretty reflective, seems to get it, seems really child focused. What do you think about your client? And those sorts of discussions should then lead to the referral to someone like you, Alison, because obviously I can't refer just my client to you. We both have to be on board with the process. And in a collaborative framework, we should be sitting down and having that discussion and both being on the same page. Because if my colleague's saying, actually, stay well away, then at least we've got that insight early.
Yep. And similarly, Sky, if a mediator, rings me, I think too, pick up the phone. Let's have a discussion about whether I think that's an appropriate case, and we can talk it through, and 2 heads are better than one. You can kind of get to the end of it to see if it's an appropriate matter, for what. I think we should be doing a bit more of the talking in between professionals and across professionals.
I think that's right. Pick up the phone a bit more. Do you have any views on, I suppose, children's voices and choice, Alison, and how that should be dealt with?
I think I have lots of views on that. But yes, I mean, like you said, it depends on their age for me, their cognitive capacity to me. I'm always thinking of how much they've been influenced, what they've been influenced by. If they're really stuck and they're going, to be to be fair, I just want, equal time, and they come in sort of saying that. To me, I'm gauging when they spit out these kind of views and wishes, what that really means underneath. Because it's a bit unusual for a kid to just walk in and say that. So I'm already got my little antennas up thinking they've been influenced by someone or something, what's really happened. But yeah, I think of course we want to give them a voice. I really like that in our child inclusive practice, we can do that at any age. We can hear their voices and get the parents to reflect on their voices. And in that way, they can be part of shaping whatever happens next in that separation process. And I think it is for me, it's that kind of uh, shaping or influence in that decision making. It's not their decision, but if the parents can truly reflect on that child's experience and what it's like to be them, then they can shape that parenting plan and how they relate to the kid accordingly and how they relate to each other, hopefully.
Is there a limit on the age in terms of younger kids?
I think most people would say down to about 5.
Mhm.
You know, some 4 and 5 year olds are revert. Some are not, but I think under that, you probably not going to include them in child inclusive practice. Um, and that when they're very young, you'd be giving it limited weight, I guess, but just trying to put a more of a developmental overlay and back to that educative kind of role that we spoke about
Mhm.
before.
Mhm.
That just made me think of something else. I would always say see kids in person, particularly
Yeah.
little kids. And I know with COVID, there's a whole movement to do this, but the way I do it, I'm happy to hear from the parents remotely. But the kid, I think, just, bring them to the office and be there in the playroom with them. And you get so much more than trying to do something remotely with children.
And what I would ask about that is how would you advise parents to speak to their kids about what your role is?
I think you can just say that they're coming in to speak, give me a name or whoever it is, the child consultant that you're seeing, try and tell them a little bit about where it is so that they can kind of know a little bit. We're going into the city. Alison's a psychologist. She sees kids all the time. Her role is, to talk to kids after separation, let's say. She'll probably have a little play with you and then have a bit of a chat and, then we're going to go and whatever you're going to do, go and get sushi.
Mm.
You don't want them to worry too much in advance, but I think it's also bad when it's like sprung on them. Or as one little kid I saw, I don't know, last year it was, and I heard her say, "Are we in a doctor's office?" All out there. There's a sibling group. And then one of, so they were all geared up that they were going to come in
The
and have a
doctor.
stethoscope. I think it's important to say it's about talking and it's about talking about our family, and there's nothing you can say that's right or wrong. And I always tell the kids too that, and I say it in front of the parents, they don't have to. They can talk to their mum and dad about what we spoke about, but they don't have to because I will. So
Mhm.
you're kind of giving them permission not to talk about it. And I'll try and water the parents down to say, I'll feed you back what you need to know. And I'll make sure that I say to the children that I'm going to do that, but with their permission to help me with the words to give the message back to the mum and dad.
Alison, do you ever have it happen that the child says, "No, I don't want you to repeat this back to mum and dad"? And how do you
Yeah,
deal with that?
yeah.
Yeah.
Yep. But I tell them right at the beginning, Dina, that that's what we're going to be doing and that I wouldn't trick, I'm not going to trick them. But I say, when we get to the end, we'll talk about how and what I might say, and you can help me work out, the words that you're comfortable with. And that's what I do then at the end, really kind of say to summarize, so this is what I heard. How could we word this? some will say that they don't want the actual words, you know, or that they don't want to be identifiable, but sometimes that's a bit tricky.
Depending on the number of children.
Exactly, exactly.
So maybe, Alison, it might be helpful to tell us a bit more exactly about how the process works from the beginning of your involvement in this process to the end.
Yep. Um, so I guess the first step is what we've spoken about is an appropriate um, matter, and I speak to the mediator, and then I normally send out an information sheet about my fees and process and how I work. I really want the clients to read the information sheet and the lawyers and the mediators so that they know exactly what it is and what it is not. Um, I think it's really important that they know that it's not a report, that they can't then get to the end and say, now, can you write that up into a report? And that they know that I'm not going to be diagnosing anyone or making any kind of opinion about mental health problems for either the parents or the children. And you really trying to sort of set the tone of it, I guess, there of what it is that it's about hearing from the child's experience and some reflective feedback for the parents to help them as the experts of their kids. So I would send out an information sheet before the parents come in, have them sign a consent form so that they know exactly what they're getting into. I would then do the interviews either in person, but alone, individual interviews with each parent alone. And then at that point, as we spoke about before, kind of make that decision about whether it proceeds or not and see the children in person in my office. I've got playrooms, a playroom there. So I'd see all the kids together if they're a sibling group. And then normally I just start from the oldest and work my way through the kids, seeing them. Then a lot of it's about the preparing, I guess, the feedback, because this is the critical part, is really preparing what you're going to feed back to the parents, how you're going to feed that back, how the kid's going to be protected and how the kid's going to be benefited by that, and what the parents can kind of tolerate, what they can't. So preparing that feedback is really important. And then after I've got a really good idea of what I want to say, talking to the mediator or the coach if it's a collab matter about what I think might be difficult for the parents to hear, what they might think is difficult, and what I'm worried about, or if there's particular things that then the mediator or coach need to kind of take on for the next step, because I can't solve the problems in that kind of way. It's more like flagging them for the mediator or the coach to take on and then have that further discussion with them.
And if we can
So,
just look at, oh, sorry, I was just going to go back to the conversations that you're having with the parents, because that's
yeah,
clearly the first major intervention that you're having.
yeah.
Firstly, how long do those conversations usually take? And secondly, what sort of things would you be asking the parents about?
Well, normally I would hold about an hour. I'd tell the parents an hour, and I'd normally keep a little bit more in reserve for the people that like to chat a bit more. Um, um, the questions really depend, but I mean, typically you're asking obviously about their separation, about how the child learned about the separation. The focus is really on the child, so I don't really care whether someone had an affair or what happened, other than does the kid know about that? How did the kid find out? That kind of aspect of it. Asking about really the child's personality, what he's like, what it's like being, little Johnny's parents, what gives them joy about being his parents, what's really difficult about it. If they have any particular, special or additional needs. What's happened, I guess, in terms of the care arrangements or the parenting plans, and how that's been, how each parent perceives that that kid has been, and that's often you think you're talking to completely different members of the family, of a different family. One person, parent thinks that they're coping really well and easily, and the other does not. So I'm interested in that. I'm interested in what the kind of current dispute is about, or what they're hoping to hear from the child, what would be hard to hear from the child, um, what they would like out of the mediation or collab process themselves, if they have any kind of agenda themselves. And all the time, I guess, again, I'm thinking about how reflective they can be. Can they take this on at this time? Because sometimes they might be able to as a person, but it might be too fresh and raw, and they're just flooded with emotions, So
Mm.
I'm asking about all that, and I do pretty much a mirror with the other parent, but obviously I'm not really talking about what one parent said. I'm just going from scratch. And no, it doesn't matter which parent I see first, but people think it does, but I don't think it does.
No. And what about the kids? What sort of things are you asking the kids through this process?
Well, it depends on their age and their personality and their temperament and how they are. So again, this is why I like to see kids in the flesh, because you can read so much from a kid, and you want them to open up. But as I said before, I'm really transparent with that consent. I would never want to trick a child, no matter how little they were or old they were, um, by not telling them about that aspect. So I always start with that before they share anything with me. And then I really just kind of dive into a bit of rapport building with the kids, um, and trying to find out really what it's like to be them. Their unique position in this. I say that I've worked with kids for a long time, um, and some kids might feel this. So when I'm sort of sounding them out, I might summarize and say, sounds like you're feeling a bit stuck, or is it like that for you? I make sure that I've got it right. If I've got this right, is this what it's like for you? Because I don't want to overlay my views on them. So I'm asking about their experience of the separation, their experience of the living arrangements, how that's been, what the transitions are like for them. Obviously, I'm not using those words. I'm using developmentally appropriate language for what age and stage they're at. What it feels like on the inside in different situations. So I might use bear cards to try and explore that, or stones, or drawings, or narratives, different ways. I might use strength cards to kind of talk about what good things that they think they have from each parent. Parents like to hear that. And then, but of course, I'm asking them all this, and then I'm then reflecting in that kind of process of what those themes are,
Mm.
over as they keep talking, and then feeding back, sort of thinking about what themes are emerging, and is that developmentally appropriate, normative? Is this preoccupying or worrying for the kid? What's actually happening for that child? So then at the end, I kind of end up pretty neutral, and give them that reassurance that they can talk to their mum and dad, but they don't have to, because I will. And thank them for sharing.
Because then you're moving into the difficult phase, which I think would be the hardest part, really, of the whole process, which is giving feedback to mum and dad or the
Yeah.
parents, because I think that would be quite a difficult conversation in some senses to have. And obviously, that's the hardest part, I would think. So how do you provide that feedback? What sort of things are you focused on?
I think it's harder to do it than when you write, because I can be quite clinical when I
Yeah.
write. But when you're giving feedback, you're obviously worried about, and hopefully you've got then the mediator or the coach or someone with you, and they're also watchful for
Are you
how
doing with them, both of them together? So are the parents both together, or are you doing separate feedback?
ideally they're together. I mean,
Yep.
ideally, you want them both to hear the same thing. They're going
Yep.
to walk away and have heard different things because that's the nature of humans, right?
Hmm.
And one will have heard me say this and the other not. But ideally, you've got them together because part of that too, you're kind of watching how they're coping. You know, if one's a bit more vulnerable and teary, you've got your mind to that, and um, being respectful, obviously, and watchful and waiting for them to recover a little bit, and then saying, "Do you want to have a little chat afterwards about that? We can take that up a bit more thoroughly by yourself." But if they can't tolerate to be in the same, even virtual space, let alone the same room, then you can do it separately. But the difficulty is, do they hear the same kind of message? So
And I guess arguably if
ideally
they
they're
can't,
together.
yeah, if they can't be in the same space at all, then maybe it might not be the process for them.
Or
But
you can say before, I kind of set them up to say, if you get a bit teary,
mm,
I'll wait and we can take it offline.
mm,
That's
mm,
okay too. You just have a little bit of time um, with each of them. So yeah, you're trying to be put them back in the hot seat as the expert and say that. So you're reassuring them, this I have only met your kids for a short time. This is just a little snapshot. You know better that Johnny better than me. But this is what I'm kind of hearing from him. I'm curious or wondering or concerned about that. So I'm adding on my layer to what Johnny said. I'm not giving quotes back from Johnny said this about you or Johnny wants that.
mm, mm.
It's a bit more nuanced, and then they're asking questions and you sort of a bit having feedback back and forth. So you're hopefully trying to help them hear it, help them reflect, and really be open and curious and wondering themselves. What we don't want them is to be so flooded with emotions that they can't cope, or so worried about or concerned or um, focused on what's the outcome. How's this going to translate into a parenting plan for me or financially for me? You want to keep them in that kind of reflective space.
Mm. And ideally, no lawyers present.
No, I get asked that, and I have done it once, but I really don't think that I would again.
Mm,
It was an unusual kind of case, but I think the problem there, Sky, for me is it would change the dynamics completely, and it's really not the purpose of it. I think we've got to go back to what the purpose is, which is a brief psychosocial intervention. It's a bit like having a lawyer at therapy. Like,
mm,
would you as a lawyer say, why don't I, so you've got depression, why don't I go and come and meet you a psychologist? Um, I think it just changes it from a reflective, wondering, curious space about the child's experience to an evidence gathering, solution focused, and they're not those two things are very different.
Nor would I want to be there, can I say? I wouldn't want to be in that conversation because I think that would be quite confronting and also not really my role. But
Well,
what
you've
I
got the
would say,
mediator. I
well,
mean,
yeah, that's what I was going to say. What I would say is that as a lawyer, I'm therefore then very reliant on that conversation being relayed to me by someone who is independent. Because if the conversation's relayed to me by my client, it's likely not going to be the full conversation.
sure, sure.
So I think from my perspective, helping me help my clients hear the feedback without having heard the feedback myself. The conversation with the mediator or the divorce coach and the mediator and the divorce coach being clear on what you've actually told the parents is really important.
Well, they should be taking notes
Yeah,
along the way, and
yeah,
then they should also, ideally have had that conversation after the child consultant's done the preparation, the feedback, and before you do the feedback. So they're already prepped, the mediator or the
hmm,
coach is already prepped for what the child consultant's likely to say and
hmm,
how the parents are going to receive that.
mm,
Um,
mm,
so, that they're really the ones that can then disseminate that information to the lawyers.
mm, mm.
It,
And they do. And from my experience, they do. Um,
so the
and
lawyers shouldn't need to be there.
no, nor do they want to be there. But we do obviously have to help our clients process it, because this is a conversation that is going to keep coming up for a
Yeah.
little while at least. And I think that in helping us work with our clients to understand the feedback that they've received comes down to really three things from my perspective. I need to be prepared. So I need to have had that very careful conversation with the mediator to understand exactly what it is you have said.
Yeah.
I need to contain it. So I have to try and contain the client to focus on that conversation and what was actually said. And then I need to
How
try
do
and,
you how do you contain them?
well, you keep it limited to, I guess, what is said. So rather than extrapolating on a comment that has been made, just focus them really on what the actual comment was. So,
Mm,
and that comes down to preparation. I found in my experience that working with the mediators closely and really understanding the points that have come out of that feedback session with a lot of clarity is
mm,
really important when I'm having that conversation with my clients. And often I'll have a conversation with my client about that with the mediator there. Because if the client then starts saying, well, actually, this is what said, the mediator can say, well, that's not
actually, that's not
exactly.
yeah, yeah.
And so that's an important part of the containment, I think, is having the mediator present with the lawyer having that conversation, because otherwise the client's saying one thing and I'm saying, well, the mediator told me another thing, but the mediator's not there. And then I'm ringing up the mediator. So I think having that session with the
Mm,
mediator present is helpful,
hmm.
because then I can speak to the client from my perspective about what that looks like. And I've got the mediator sitting there clarifying
Mm,
exactly what was said as an
mm.
Are you
independent
usually
person.
aiming to do this straight after the feedback session?
No, I give them a bit of time because it's part of the reflection. I think if I was to speak to my client immediately after they'd spoken to Alison, I think that would be really difficult for the client, because sometimes they're hearing some really difficult things. And I guess over
Mm.
time, I've learned to realize that an immediate reaction to hearing something difficult may be very different to the reaction that you get 24 hours or 48 hours later when they've had time to process. Some
You need to
clients,
process it.
you do need to
Yeah,
process
yeah.
it. Some clients are better in the immediate in processing. Some people are better at processing things quicker. But generally speaking, I would give my clients a bit of time to process it. That also gives me the opportunity to be a bit more prepared, because I can have that conversation with the mediator and I can work out how I think best to approach that with my client, particularly if my client's received information that they may not have been expecting. So it also
Mm.
gives the lawyer time to prepare as well, because it can be a difficult conversation, though,
So what do
from
you do next? What do you do when you have all that?
in terms of the next step or in terms of the conversation.
The conversation with the clients about, how they can, what they do with this information.
Mm. Well, if I've given them some time, generally it's a calmer conversation than if we do it immediately. So I've learnt that it's better to give a bit of time. And if I feel that the client is really struggling and is not managing the feedback well, or is not taking on board the feedback, obviously I'm looking at referring my client off to their scaffolding. So perhaps working it through with their therapist, because I'm obviously not that person. Working it through with their family, strongly advising them not to be working it through with the child, because that's clearly not to happen. But in the ones that I've done where there's been feedback sessions and I've had to speak with clients about feedback sessions, I'd say the overwhelming majority have been really positive, because I don't think that they would be in that process if they didn't have that ability to reflect.
Mm.
And if they're given time to reflect, and often they're not talking to me until they've spoken to you and the mediator, I'm the third person in the row, they're at a point where they are at the reflection stage and they are in
Mm.
the ability to act on that and act on it generally. And I'd say in 95% of cases positively.
Mm. So where do you go from it? What happens next
Well,
for a lawyer?
if from a lawyer's perspective, it might be that we enter into a parenting plan. We sit down and say, how are we going to actually implement this practically? I think it's better to, in these circumstances, have something that's much more flexible. So a parenting plan is more flexible than court orders because it means that you can review it. So we can, coming back to what we spoke about at the beginning, Alison, if we need to, we can review how things are
Yeah.
working in 6 months' time or 12 months' time. Whereas if we've got court orders in place, it's much harder to reflect that in a consent order. You can't sort of have a crystal ball as to how things are going to turn out in an order. You can
Mm.
try, but it's difficult. Whereas
Not
a
to mention the
parenting plan,
money.
yeah, exactly, very expensive. Whereas a parenting plan is much more flexible. So you can factor into the parenting plan the fact that we might go and see Alison again in 6 to 12 months and see how the kids have managed the change or whether this is working or whether we need to tweak things. So after having that feedback session with you, really, I'd be sitting down as a lawyer with my client, with a mediator, the other client and their lawyer, and trying to nut out something that actually puts into practical effect what's come out of that session so we can hopefully reflect the child's position front and foremost in that document.
Yeah, it makes sense that, that's really what we're hoping is the child has some influence in that.
That's right. But sadly, if we can't do that, then the next step is where we don't want to go, which is to court.
Mm.
And that's when things blow up. But we'd want to avoid that. And that's the whole purpose of child inclusive practice, to have the child
Yeah.
front and center.
We've all seen that.
Yeah.
Yeah, this is exactly what we're trying to avoid.
We're trying to avoid court in the formal process and the
Just a
cost.
logistic question. Say you start the collaborative process and it stalls and court proceedings are commenced, and then eventually they decide, oh no, I want to go back to the collaborative process. Are you able to do that, or it's once and done, and you can't go back to the collaborative?
I think that so when we talk collaborative, there's a formal collaborative process that involves a certain process. So you have to sign a certain document that means that as a collaboratively trained lawyer, if the matter doesn't resolve by consent, you won't act in litigation. So your client would have to go and find another lawyer. I and the term collaborative is used a bit interchangeably. If we're looking at the formal collaborative process, I'd say no. But if we're looking at the collaborative process where we really just want to try and work this out in an amicable way for the benefit of this child, then I don't see why you couldn't revert to those sorts of processes once litigation had started if both parties were agreeable to that and everyone was on board that that was best for the child. I think you'd have to agree, obviously, that it be confidential. I think for it to work. I think if it's not confidential, then it's not really collaborate. I mean, what do you think about that, Alison? Do you think that that would work if it was not confidential?
I think that once the parents had gone past that, it'd be hard to get them back to think
Mm,
collaboratively because then all the,
mm,
like we said before, then all the affidavits are written, all the, horrible things they've said and done over the last 20 years comes
mm.
out.
I've never
And
seen it. I've never seen it happen once proceedings have started, but there's always ways that you can try and look outside the square in terms of getting your clients back on track in terms of focusing their kids. And that's, I actually think, and it's probably a topic for another session, Dina, but I think that that is a really one of the reasons why those short reports are so important for the right cases, because they are also another form of early intervention,
mm,
which in
mm.
the right cases can really lead to reduced litigation, I think, if
Yeah,
you have the
I
right.
agree, Sky. And sometimes in those child impact reports, you can say as the writer a lot, actually for, shorter, briefer, earlier intervention for a lot less money.
Mm. I guess it's like a staggered process, isn't it? You've got the really child inclusive practice, which is the least formal, the most reflective
Yeah.
step. Then you've got like a child impact report once proceedings are commenced, which in the right cases can actually steer a matter out of the process, and give ideas to clients
The
about
mediation.
scaffolding and
Yeah.
recommendations. And then you sort of go to the next step, which is where you've got the much more formulaic, extensive report.
Yeah.
And of course, you can jump off the pathway at any time, as we all know, if you can reach agreement.
Well, that was so informative. Thank you both.
Sky and I could keep going for another hour, but I think we've run out of time.
We
We
have.
have had a few quick questions come through, so I might put them through. Um, so one questioner has asked, is it essential to the process that there is a mediator or coach involved?
Again, I have done it where that wasn't in a mediation. Um, but it's very unusual. Then it's not really child inclusive practice because you need then the mediator or a coach to do that feedback and to do all the roles that we were talking about. Otherwise, the child consultants have got to hose them down and prepare them, and you can't do all those roles. So I think the short answer is yes, you need a mediator or a coach.
For that collaborative process. But I think that there are other sort of ways that you can use someone like yourself,
Oh,
Alison.
sure. Then it's just a child consultation.
Yeah, or just working with parents to understand their child. There are those sort of alternate
Yeah.
avenues as well,
Or
which
just
are,
an aspect of it, then it's
yeah.
just literally like a consultation about
You,
autism or
or you've got a
ADHD.
baby who's 6 months old and you've
Yeah,
just separated, and what, is
developmental needs.
developmental needs
Yeah,
need the parents take into account. So I think we've got to remember, Dina, that child inclusive practice is quite a formulaic process that we can use as practitioners to help children that have had recently separated parents. But there are other avenues also that we can look at to help our clients as well. And I think fundamentally it all comes down to education, because if our
mm,
clients are educated and understand the impact on their kids of conflict, then that's going to obviously help those children who are at the center of the conflict if their parents understand the impact it's having.
yeah. Rather than waiting 2 years, 7 years in litigation and having that aha moment then.
Yeah, it's too late. Oh,
And just
hopefully not.
talking about the children's voices. So, Alison, would you ever, for an older child, directly ask them what sort of living arrangement they want, or do you sort of do it in a more roundabout way?
In a veiled way, you're sort of asking, what's that like for you? How do you like that? If it was, wishes, what would that be like for you? So not directly, but indirectly, you trying to kind of get some understanding of what it is they want, if they know what they want.
Um, well, thank you so much. As I said before, that was so informative. If any of the solicitors out there are interested, we will be sharing Alison's contact details. So I think it is really underutilized avenue. So do turn your minds to it. And I guess the other point is, as early as you can, you should be turning your mind to whether this is appropriate in this particular matter.
Yeah.
But,
Thanks,
well,
Dana.
without further
Thanks,
ado,
Sky.
I'll wrap that up. To everyone listening, we have another webinar next week with Gabriella Pomare, uh, focused on her book, The Collaborative Co-Parent. So in this session, we were sort of looking at focused on the child's point of view, whereas we'll be taking a different spin and we'll be talking about how you can, I guess, turn your clients' minds around to that, make them a bit more collaborative. Thank you once again to our presenters, and we'll see you next week, everyone.
Thank you.
Thanks. Bye.